My name is Hillary Madden. I am assigned to this case. We are here on the original filing of the grandparents, okay? Paternal grandparents. And I understand—
They're not paternal grandparents.
Mr. Toth, I will mute your microphone so that way you cannot speak if you cannot follow directions. I do not want you to do that. I do not like doing that to people, but I have to in cases where they continue to interrupt me. I understand from your filing that you disagree with Micheal being considered the paternal grandfather because he's not your biological father. I understand that. I have paternal grandmother and her spouse. But I do have a paternal grandparent here, and that's paternal grandmother. Okay? They filed first. They filed on January 9th. Then father filed today on February 21st. You filed a pro se document for a writ of habeas corpus. It's not technically something that gets filed in custody. It's not really a pleading of any kind. It does not exist in custody. But I got the gist of your filing. I understood what you were saying in it. However, it was phrased. Okay? Now, I also see Gladys raising her hand. Gladys, you have not filed it.
I really
Go ahead.
I need a translator porque no estoy entendiendo mucho de qué ustedes están diciendo.
So here are a couple things that I want to address before anybody else interrupts me again. Mother is requesting a continuance for an interpreter because that's the only thing I can do right now. I can only continue it if an interpreter is requested because I cannot have one today. There is no—
This court doesn't have jurisdiction over the matter.
Mr.
And me being
Toth,
alienated from my child.
Toth, please let me finish. If you interrupt me again, I will mute your microphone. If you interrupt me again after that, I will dismiss you from the custody conference. I am not asking for a lot here. I am asking to get through a couple of procedural matters. That is it. Mother is requesting an interpreter. If she wants an interpreter, I have to continue the conference because I do not have one available, and she is permitted to know and understand what is being said at the conference today. Secondly, paternal grandparents are claiming they have standing. Father is obviously challenging that standing. He's challenging standing, and he's challenging jurisdiction and venue. In his pleading, he has indicated that the child was born and raised in Mexico, that the child was not permitted to be here for a year, and that it was a short time. And he's also challenging the paternal grandmother's ability to file for custody. I cannot address either one of those two things. As a custody conciliator, I do not have authority to say whether or not a party has standing and whether or not Monroe County is the proper jurisdiction. Those are things, those are matters that would have to be addressed by a court at an evidentiary hearing. So what I am inclined to do is to make a recommendation that the court schedule an emergency evidentiary hearing where an interpreter would be available for mother because she does not understand, and where the court can address father's challenges to standing and to jurisdiction. That is the only authority that I have. I cannot grant standing. I can't deny standing. I can't grant jurisdiction or deny jurisdiction because I don't have that authority. Only a judge after an evidentiary hearing can if there is a challenge to those things.
May I speak?
Go ahead, Mr. Toth.
I haven't seen my daughter alive in too long of a time. I have no idea what's going on. And for the paternal for Micheal Ledesma to be claiming to be the paternal grandfather when he knows he is not, only gives us so much suspicion and alarm. I need to see my daughter. She was never given legal custody. This was a visit turned into a kidnapping, okay? And it is an interference of child custody that I can't even see my daughter just because she makes a fabricated order of protection while I'm in Mexico. There is absolutely no fear of danger for me if I'm in another country. Okay, this was only as a way to manipulate and make a mockery of this system to disguise a kidnapping, okay, as a legitimate custody hearing. It is a disgrace that this mother is suffering and crying every single day because we have no idea what is going on for our baby, because these people reneged on their agreement with us. It was only a visit. They're not allowed to do this, okay? And what I need emergency custody. I need emergency custody for the interest of my child, because when somebody does not pass the moral character of what they're doing to make a mockery of this court, they do not pass the moral test to be look how old they are. What are they going to do with a 2-year-old?
Already made it clear that I cannot have a custody conference today if you are challenging standing and jurisdiction. If you're challenging those two things, I cannot proceed.
I am challenging every single part of this charade.
To listen to what I'm saying. The only step that you can take at this point, if you are challenging standing and jurisdiction, and because mother is requesting a continuance, is for me to recommend that an evidentiary hearing be held so that all of this can be litigated. If that's what you're asking for, then there's no purpose for this custody conference to continue, because I cannot decide standing. I cannot decide jurisdiction.
Can you decide parenting time? Can I see my daughter?
No, because I can't have this custody conference.
So if she doesn't have legal custody, what stops me from going to get my daughter? Please tell me that. In order of protection, how about somebody else get my daughter?
I can't do anything. I can only.
So why are we having this if you can't do anything?
Because you just challenged standing today. You only challenged standing today by filing a motion. The court did not know you were going to challenge that. A custody complaint gets filed, a custody conference gets scheduled. You filed your motion this morning. So it was impossible to schedule anything other than a custody conference because you did not file your challenge until this morning. Mother did not notify anybody until now that she needed an interpreter. So even if we could proceed, I would still have to continue it.
You really can't proceed because you're out of jurisdiction. You know it. So I would like, as soon as possible, emergency consideration of the jurisdiction of this matter, and to get Chelsea home. That's what this is about. Okay, we cannot just make the petitioners cannot just buy time.
That I can't consider jurisdiction. I've already said that. I've conceded that. I said that a judge has to decide that.
I need to see a judge as soon as possible, please.
At this point, I'm going
to emergency.
Your microphone, and I'm going to turn it over to Attorney Cohen because I would like to hear what his position is and what his client's position is.
I'm reporting him to the board. That's his position.
Okay, so if I guess in response to a preliminary issue, if Mr. Toth is so concerned about timing, he does have the option to withdraw his objection to standing and jurisdiction.
Hey, Barry, I don't even think you should talk in this matter, okay? Because what you're doing is you're representing kidnappers, okay? There's a criminal complaint.
If you cannot be respectful, then you will be muted.
Respectful of what's leaving his mouth? Yeah, you might.
Go ahead, Attorney Cohen. I've muted his microphone, and if he unmutes and talks again, I will dismiss him from the conference. Go ahead, Attorney Cohen.
So he does have the option to withdraw his objection to jurisdiction and standing, and then and also Gladys, Mrs. Toth, has the right to withdraw her request for an interpreter. If each of them does that, then we can continue. Is that correct?
Well, yeah, I'm not gonna ask Miss Martinez Toth to withdraw her request for an interpreter. She can't understand what's being said. That's not fair to her. That puts her at a severely weakened position.
That's fine. So basically, my position is I've got really very little to say because you are correctly representing the position of the court when jurisdiction and standing are challenged. I just want Mr. Toth to understand that by doing that, there will be a delay caused by his request for easily 1 to 3 months. In addition, if he is bound by a PFA, a temporary at this time, and which will go to a hearing on March 6th, 2023 for a final PFA order. He cannot appear at the house. He cannot talk to, communicate with, or in any way contact Alexandria, Toth, or Micheal. If he does so, well, there's already been a violation of the PFA order, and that violation will be prosecuted. It just happened recently. The Toth Ledesmas are in the process of contacting the district attorney's office to file a petition for a violation. If it continues, every time it happens, another violation will be filed with the court. As you have seen, Mr. Toth isn't interested in hearing anyone's about anything, and you have heard his position. There is nothing in any of the paperwork that he's filed which supports the truth. And so we will, Grandma and Grandpa will continue to parent Chelsea until there is a further order of court. I can get into a lot more detail, but I don't know that it's relevant at this point because of the ruling that you've made.
Yeah, and unfortunately, because I cut Mr. Toth off when he was talking about facts of the case, because again, I can't get into those things if I can't have a conference, and I'm not going to have a conference if there's a challenge to standing or to jurisdiction, and more importantly, if mom can't understand to participate, because it's not fair to mom to have a custody conference where she can't understand what is being said. I will say that although I recognize that there is a PFA or a temporary PFA that has been filed, I saw the filings for that, there is no such PFA regards to mother, Gladys. So technically, there is nothing preventing her from being able to communicate with the children if paternal grandmother is agreeable to that. However, it could not be used as a mechanism to allow father contact through third parties. So Gladys, there is nothing preventing you from having contact with the paternal grandmother and the child, so long as father is not using that as a runaround to try to get in contact himself through a third party.
I can tell you that.
Can I tell Gladys a little bit what's going on in Spanish?
No, hold on, sir. Go ahead, Attorney Cohen.
I can tell you that the grandparents have repeatedly reached out to Ms. Martinez Toth, and they have had communications. She's had communications with the child. Sometimes she appears, sometimes she doesn't, but I've instructed the Toths to continue to reach out to mother because she is not subject to the PFA.
Gladys, vas la fiscal a poner este criminales en la cárcel ya.
Sir, I don't know. I have no way of verifying.
You don't have jurisdiction. This is a charade. I'm going to sue all of you.
Mr. Toth, I'm going to dismiss you from this custody conference at this point. Okay. Gladys.
So I will continue to encourage the grandparents to reach out to mother.
Necesito a Alex aquí. Si no está mi esposo, yo tampoco puedo continuar porque él es el que me dice qué está pasando. Si no, no puedo saber qué está pasando. No entiendo. Él es quien me está diciendo qué está pasando. Necesito que regrese mi esposo a la conferencia. Si no, no voy a poder seguir yo tampoco.
And I'm sorry, I do not speak Spanish.
Lo mismo me pasa a mí con usted. Si usted no me entiende a mí, yo tampoco le entiendo a usted y no sé qué está pasando.
I see Alexandria raising her hand. I don't know if
de la videollamada.
No, Attorney Cohen, you're saying no, you don't want her to talk.
No, I'm talking about my clients who want to speak. They have nothing to say,
Okay.
and should not speak. And so I have no idea, sadly, because I do not speak Spanish either,